Hello everyone, Louis Setti speaking as the Blue Ridge Reporter on Friday, January 6, 2012, and let's have fun on a January winter night the way lawyers do, okay? This is lawyer fun. This book is something I recommend to you. You can see it there? The Exhaustive Concordance to the United States Constitution. The Exhaustive Concordance to the United States Constitution. Dennis Bizacco, editor. It's got a topical index and a rapid reference constitution. If you're going to follow politics and you're going to watch the media and you're going to believe what you're told, you're going to be misled. Allow me to assure you that the best constitutional lawyers, so to speak, I ever knew were not lawyers. Lawyers are misdirected in law school to think the Constitution is that great assemblage, confusing as it is, of the various decisions of the United States Supreme Court. That is not true. This is the Constitution. In fact, this little pamphlet right here is the Constitution. We're getting some light glare on that. Is the Constitution plus the Declaration of Independence, all in one little book. You can see that, the Constitution of the United States, Declaration of Independence. You should be able to go through this. Any layman who can read high school English can have a very firm grasp on what the Constitution is and what it requires. You need to have some basic understanding of American history, only to understand the context that the Constitution was proposed and ratified in, and also have some understanding of the grammar of the day and the meaning of the terms then, and you might get yourself an old dictionary. If you can find one, or more likely find some definitions as they existed at the time of the ratification of the Constitution, because that was what the document meant based on the words as they meant then. Okay? So that's a prelude to saying don't just sit back and listen to all the political commentary, much of which is really off the mark when it comes to constitutional issues. In fact, I suspect there is an assumption that one of the things that's most talked about in any election cycle is constitutional, when in fact it is completely unconstitutional and nothing more than an egregious breach of what the Constitution provided. And I'm speaking about the federal campaign finance laws. Let's go back, maybe to a time before you weren't even here, or maybe it was a time when you weren't really aware, to a year 1973, 1974, the Nixon-Watergate scandal. You've heard the phrase, never waste a crisis. Well, it's not new. In 1974, the Democrats didn't waste that crisis because in the scandal, some large number of bills, currency bills, United States currency, were retrieved in a suitcase. And this was money moving into the campaign, which in those days didn't have any campaign finance laws, at least like we know them now. There wasn't this whole big, elaborate arrangement of complicated, particular, picky campaign finance laws. And to my knowledge, other than fraud or tax evasion, there was no federal issue regarding the financing of campaigns. But the Nixon scandal, as it was called, allowed the Democrats to say, you see, we need to clean up politics. We need to get the money, the dirty money, out of politics. And they sold that idea and got it passed by Congress sometime around 1974, 75, somewhere around then. So the first federal campaign finance law went into place. And what was it designed to do? It was designed, as all laws of that type are designed, to skew the election process in favor of those who proposed the law and got it passed, as they nevertheless said, we're doing this for you. To clean up campaigns in the United States of America. So, in any event, the law has no constitutional basis. And if you are aware of what the Constitution provides, and you can do that very easily by having a book like this, and let me turn to the exact article. This is the authority in the Constitution that Congress has regarding federal election laws, okay? Article 1, Article 1, and in this book it's labeled 4:1A, but just look in Article 1, a few paragraphs down, you'll see it. And it says this: the times, the places, and the manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. Okay, so what do we see right away? The times, the places, and the manner of holding the election for senators and representatives shall be controlled by the various state legislatures in their states. All right? But, it says, Congress may, at any time by law, got to pass an act of Congress, get it signed by the president, okay, make or alter such regulations, not make any regulations, make or alter such regulations, referencing back to times, places, and manner of the elections, except as to the places of choosing senators. So Congress could make a law regarding the times, the places, and manner of choosing members of the House of Representatives, or the times, the places, but the times and the manner of choosing United States senators, except as to the places of choosing such senators. All right? Okay. Now, what does that mean? Congress's authority stretches to times, places, and manner of what? The elections for representatives and senators. The election occurs when people cast their votes and they're counted. That's the election. If your business closes, if your state closes taverns, or if schools close, they close on Election Day. They don't close on Campaign Finance Day. You see, the financial arrangements for the candidates to conduct their campaigns, that's not the election. But as many things happened, that law was passed. The United States Supreme Court approved it. The language of the Constitution is to the contrary. There is no basis for that overreaching by Congress to control the fundraising. They have limited authority to control the time, place, and manner of the elections, but not the fundraising process. Not only did the United States Supreme Court approve that law, certain individuals challenged it to say, okay, if that's the general rule for public members contributing to campaigns, and I'm just pretending here, the immensely wealthy individual can use all of my own money that I want to run. And the Supreme Court said you could. That was still permitted in the land of liberty, but only by one vote, 5-4. If one vote had swung another way, the wealthy people could not have even used their own money to campaign. So, for those of you who have some historical recollection of campaigns in recent decades, there would have been no Ross Perot, because he funded most of his campaign himself. He said, look, I'm fed up, I want to run. Here's the money. What do I pay for the media? I'll do it myself. There would have been no Malcolm Forbes, who funded most of his campaign, such as it was, some 15 years ago or so, publisher of Forbes magazine. There would be no probably Mitt Romney, because his first campaign was funded primarily by his own wealth. Now he's drawing in other funds. But that's how aggressive the federal campaign laws were, and how the Congress and the President and even the Supreme Court tried to shut down citizen participation and keep control of the flow of money into the campaigns, because that gave the government control and kept the private citizen out, and they even tried to keep out the very wealthy private citizens and give control again only to the two old parties. So that's the history of the federal campaign finance laws. Now we're going to talk about that some more, but I happen to live here near the Blue Ridge Mountains. The Blue Ridge Mountains dominate the landscape, and you don't think about them much. But if you were to be young and wake up here one morning and open your eyes for the first time and look around you, at some point you become aware, you become cognizant of the fact that there are the Blue Ridge Mountains. And you would say to yourself, well, the Blue Ridge Mountains are always there. Why would I question them? For those of you who are young or younger, and you see things happening in the political realm, and you assume, well, they were always just there. George Washington himself made the federal campaign finance law, did he not? James Madison? No, that was a recent, unconstitutional, statist development. And you should be aware that these things were not always in place and should not be in place even to this day. We'll talk more about the federal campaign finance laws. Thank you for listening.